Hey intellectuals, in this video we are going to understand about the natural rights theory. So natural rights theory in the introduction part itself have explained quite a bit about this natural rights theory, and now we are going to understand it much deeper with case laws, and we are going to understand the limitations of this natural rights theory. This natural right theory clearly states that every creator or inventor will have natural right over his ideas. If he is creating or inventing any product, he will be having natural right over that product. Okay, this is what natural right theory is stating. So we are saying that he will be having right over his invention or creation or his IP property. First we have to understand what all the inventions or creations will be coming under this IP property. That is the first point. Only if we understand if it is IP property or not, we can come to the conclusion if he is having natural right over that property. Okay, so for this we can understand this with this case law, Diamond versus M. Chakrabarty. So in this case law, the court would have held that Chakrabarty's creation of genetically engineered bacterium was sufficiently unique and not merely a product of nature. So here we have to understand that there must be some human intellect used. Mere discovery cannot be patronized. Okay, mere discovery cannot be patronized. We will be understanding these concepts in detail when we are studying in detail about the Patent Act. Okay, now for providing patent for any invention, human intellect should be used. That should be novelty. Okay, and it should be unique also. So in this case, the court held that the bacterium found out by Mr. Chakrabarty was unique and it is not just a product of nature. So it is not just mere a discovery, but he has used his intellect. His human intellect is being used. So patent was granted. Okay, so by granting patent, the court recognized that his invention is a result of human innovation and effort. So it should be unique. Human innovation must be there and there must be effort also. Okay, so we should not say that it is already available in this world, so I have just discovered it, so give me patent because I used my physical labor to get that, to discover that. One cannot say so. For treating a innovation or invention as an IP, we must have used our intellect. Human intellect should be used. It must be unique. Some effort must be made. Okay, all these things are the criteria for stating that it is an IP property. Okay, so if a product is created on this basis, we claim it as an IP property, and over that IP property, the creator or inventor will have natural right. Okay, this is what natural right theory in IP is trying to stress upon. Okay, now let's understand about Haddad versus Grimshaw case law. It is a very important case law because it has emphasized that certain materials and elements may be common and not subject to patent protection. So there will be some products will be there, will be some elements that will be very basic. Okay, it will be very basic and we cannot get protection for that. We cannot get patent protection for that because it is a very common product. It is a very common raw product which will be used for producing many more inventions. So we cannot get patent for such very common products. So this is what this case law will be trying to stress upon. But however, if that particular product, that basic need product, if it is used in different combinations to bring out different innovations, different inventions, then it is worthy to get the patent. Okay, so if it is the similar raw material which is used for by and for similar purposes and by all the industries, or if it is used by all the people or for all the innovations, for like most of the innovations, if that particular product is used, we cannot get patent. But if the particular product, when used in different mixtures, different textures, if you are getting a new product, a new invention, that particular invention is worthy to get patent. But that particular raw material cannot be patentized. This is what this case law is trying to stress upon. Okay, so it is very, very simple that you must have human intellect, effort must be there. Only then we can claim this natural right thing. This natural right can be applied only when there is human innovation and effort and uniqueness. and also this common products cannot be patronized, because again we have to think about many more inventions and social good should be thought of here. Okay, if you are just giving patent for that basic product, not everyone will be able to access it. Okay, so new innovations and new inventions will not be happening because this is patronized. If it is patronized, not everyone can use, so new innovations will not happen. So that is why what we are doing, we are just trying to not patronize these basic raw materials. Okay, so for claiming natural right, there must be human innovation, there must be uniqueness, and there must be some effort, and it should not be very basic. That should not be a common good, common raw material, or common good for the purpose of creating much more creations. It should not hinder much more creations. That is what this theory is stressing upon. So for these creations, for the basic raw materials and these things, we cannot claim that we have natural rights. Okay. Now let's try to understand how this IPR laws reflecting the natural rights theory. So it is very simple. We all know all these 3 points. It is very, very simple. In case of copyright, we are granting exclusive right to the authors for their creative works, and we are protecting their expressions, and we are allowing them to use it. Okay, so this aligns with the notion of owning the product of one's intellect labor. So it is very much clear that in copyright we are giving some exclusive right. Same in case of patent. In case of patent, we provide inventors with exclusive right for their novel and non-obvious inventions, and we incentivize the innovation, and we also reward their effort. Okay, this is the reflection of right to control and benefit from one's intellectual property. In case of trademark, again we protect the distinctive symbols and brands associated with the goods or services, and we prevent others from misleading the consumers and ensuring fair competition. Okay, so these are the examples. We can state that how this IPR laws are reflecting this natural right theory. So now we are going to understand the limitations and challenges. Okay, the first limitation is balancing with public interest. When there is absolute monopoly based on natural right, it could hinder the progress and access to knowledge. Okay, so when we are giving a absolute monopoly to the creator, it will hinder the progress to the access of IP knowledge. So this is the first limitation. Second limitation is collective right versus individual right. If we are giving natural right theory a liveliness, and if we are applying it, we have to balance between the collective right and individual right, because the individual who has created will have natural right over his property, but it should not affect the social right also, the collective right also. The society should also get benefited. Okay, so this balance should be there. We have to check and balance this. For example, take in case of traditional knowledge. In case of traditional knowledge, it is very hard to determine the ownership because it is being used for lots and lots of years. Okay, so in that case, this is a complex issue. When we are using this natural right theory, when we are trying to use this directly, it will be a very much a complex thing. Okay, in this traditional knowledge, all these things will be dealing it later in our next slides. In the next subsequent videos, we'll be understanding it much better. But just understand the collective interest versus individual interest has to be taken care of when we are applying this natural right theory. Bluntly, we cannot apply this natural right theory everywhere. There must be some cut and balance. We have to balance between both the natural right and the collective right. Interpretation and enforcement. The interpretation and enforcement of IP laws vary across country. It will be varying across countries, and we have different cultural values and we have different economic priorities. So this can lead to inconsistencies and challenges in the global application of this natural right principle. Okay, so these are the challenges. So hope you understood what is natural right theory in detail. So in the upcoming series, we'll be understanding about the next theories like utilitarian theory, personality theory. All these theories we'll be understanding it in the further videos. So please do hit the follow button and stay tuned.